So what if the debtor doesn't pay? You've issued your claim, you've been successful, you've got your judgment, you've got your award, but the debtor's not paying up. What options are open to you? Well, the first point to make is that as far as possible, you want to look at this question before you even start the claim. Does the debtor have money? Can they pay? You may not have the answer to that, but it's a consideration that you should look at before you even issue proceedings. And of course, there's a huge difference between the debtor choosing not to pay and being unable to pay. There are, broadly speaking, 6 points to consider on this. Firstly, if it's a money judgment, there's normally scope for approaching the debtor and trying to agree some sort of payment plan with them. However you seek to enforce a judgment, it's unlikely that you would get payment immediately. And if the debtor agrees to pay you in instalments, that may be the most efficient way of getting your money. Secondly, you could consider instructing a bailiff or a High Court enforcement officer. They attend at the debtor's premises or business premises in order to recover assets to the value of the judgment. This may be appropriate if we're aware that the debtor has assets or the business has assets. Third, you might consider what's called a third-party debt order. Now this is effectively you applying to court to say you've got a judgment and you would like the debtor's bank to freeze their assets and pay the money that they hold for them over to you to satisfy the judgment. Now this is to a certain extent always a speculative application because you won't know how much money the debtor has in a particular bank. But if you know, often in your relation, if it's a commercial relationship, you may well know which bank the debtor banks with and an application can be made. Fourth, you could consider what's called an attachment of earnings application. So this would be relevant if the debtor is an employee. And the application involves asking the court for an order that the employer pays part of the employee's wages to you in satisfaction of the debt. Again, this is unlikely to pay the judgment immediately, but it will guarantee you over a period that you'd get your money. Another option to consider is what's known as a charging order. And this relies on knowing that the debtor owns property, but it allows you to apply for an order that attaches the debt to the property in much the same way as a mortgage works. Now that doesn't mean that you'll get the money in the short or even medium term, but it does secure the debt and ensures payment eventually, or likely ensures payment eventually. Finally, and very much the nuclear option, if there can be no agreement reached or the monies can't be obtained in other ways, is to consider pursuing the debtor's insolvency. So if they're an individual applying for their bankruptcy or a company winding up. Now the first stage in that process is what's called, it may well be what's called issuing a stat demand. Now the spectre of winding up or bankruptcy is obviously hugely significant to anybody, and raising this as a possibility can be enough to prompt payment or a reasonable payment plan. The disadvantage, of course, with that is if the debtor cannot pay, and they cannot pay because they have no money, the chances of you recovering any substantial amount of the judgment is very low, and you'll likely be in a pot with many other creditors. So to summarise, if you're in a position that you have a judgment, having gone through the court process, but the debtor is not paying, what can you do? There are various ways and means to try and enforce that order, but there are no guarantees that will lead you to certainly quick collection of the money. If payment of the money is not a priority, you have the option of securing the debt. And if that isn't an option and you're left with no other choice, you might consider petitioning for their bankruptcy or winding up.